Okay, everyone. So thank you very much for everyone for connecting on time. Uh, Today is our last training workshop with the theme of IP and data protection rules in Brazil. We have the pleasure to count on the team of Dimarest Law Office. Before we start, I just want to have few reminders with the help of Felipe, just to remind you that this is not our last meeting. We still have an appointment at April 22, when we will review the immersion experience with you, the review of the agenda. Also, I kindly request everyone that still needs to fill out the form with the information on food restrictions. Where are you staying in the cities of Florianópolis, Curitiba, São Paulo? Please do it. We are finalizing our agenda and we need to send the final list of participants. Also, as a final reminder, I remember that the BizDev consultants, they are hired and they offered to schedule a meeting, a one-on-one meeting with each one of you to understand your solutions. So if you haven't scheduled your meeting yet with Tiago, please do it quickly. This is Philip. I don't
Yeah,
know if I lost anything.
no. That's it. Those are the more important ones. Very much encourage you to schedule the meeting with Thiago as soon as possible. He's the business developer that's gonna find meetings for you guys here in Brazil, and to fill up the form to not only for you for yourself but for the rest of your team. We need to know of everyone from each company that is coming. So maybe, oh, okay, you filled up the form for yourself, but you know that your colleague from your company hasn't. Please encourage them to do so, because a lot of places that we need to go, we need to send a list of who is participating, so that would help us a lot. The other news that I just arrived for me, even Julia doesn't know it yet, but we just received the first report from the business strategy, and I'm just gonna give a quick overview here to see if everything is correct, and then I should forward them to you so you guys can give it a read before coming to Brazil. Okay, so that should be going your way in the next couple hours or maximum tomorrow. All right,
Fantastic,
that's
Philip.
it.
Amazing news. So let's start. I will introduce to you Tatiana Campello and Tomás Paiva, both are partners at Dimarás Law Office. It's a traditional law office in Brazil. Tatiana is partner and head of intellectual property at Dimarás, as well as Tomás. He's also partner at Dimarás and head of the areas of telecommunications and privacy. Tatiana, you have the word.
Thank you. Well, we appreciate so much the invitation from ScaleUp, and myself and my partner Tomás are going to be here today to share some general information about intellectual property and privacy, but we welcome you to make questions. I think the idea today is to give you an overview of the two areas, but to invite you to make questions and share information, I think will be much more interesting for the time today, to exchange information, to make questions, and to clarify some points that you may have from the Brazilian market and how to do business in Brazil. And then the presentation here, just a brief guidelines that we are going also to provide you at the end of the presentation today, but feel free to interrupt us and to make any question that you have in mind. I will start with the intellectual property part, and my partner will end with the privacy database and aspects at end. In Brazil, we have this general idea of intellectual property being like the umbrella of the area. And on the intellectual property area, we have what we call the industrial property. I will explain to you a little bit the difference, but we can keep the idea of the intellectual property being the big area, the big umbrella. Under the intellectual property, as a general international concept that you have, we have the copyright pillar, we have the industrial property rights, and we have what we call the sui generis rights, sui generis protection, which are more the specific rights that we have, such as plant variety and other specific rights that we have in the law. I will focus my presentation today a little bit more on the general and more common rights, which are the copyrights and the industrial property, because these are more the general rights that we have on the day by day. But of course, I'll pick also call the attention for plant variety, which is also some important aspects that we have, and important industry, especially for Brazil, for agricultural business that we have here in Brazil as well. But coming back here, we have the copyrights, what we call the related rights, the software under the umbrella of the copyrights, and the industrial property, which is the normal, the famous, the trademarks, the patent, industrial design, and the geographic indication. On the next charter here, and I know that the letter is a little bit small, but you're going to receive the presentation later on. We try to summarize here the main topics, let's say, of each of one. We try to summarize what type of deadlines, what type of protection, who can request the protection of each of these main rights here. But basically, trademarks, patents, and industrial design, you need to request protection in Brazil. We do have priority rights under some international treaties that we have in Brazil signed, but we need to request local protection. This is one of biggest mistakes. We receive sometimes international license agreements that the people ask us to review the agreement and think that, oh, my trademark is protected abroad. I think the trademark is already protected in Brazil, which is not the case. And then we really need to understand whether or not your main purpose of the agreement, the trademark or the patent, will be protected in Brazil as well, because this is a territory-based protection. Again, we do have some international treaties that will cover the extension of the protection if it was required in that way abroad, but we need to confirm such extension in Brazil. We will also have some deadlines that you can use as a priority right, but we do have to confirm such rights under the local protection as well. And then if you have a wish to be in Brazil, if you are even not exactly immediately, you have to be aware that you need to protect your rights in Brazil. Otherwise, this does not guarantee exclusivity use for you in Brazil. Knowing that the trademarks, the patent, the industrial design, software, copyrights, they can be owned by foreign entity, no problem for that. You don't need to be a local entity to be the owner of such rights in Brazil. It means that you can, for the trademarks, patents, industrial design, the only requirement is that you need to be represented by a local law firm or by a local attorney in Brazil. But you can, as a foreigner, you can have the registration under the name of your entity abroad, which is a great advantage, but you don't need to incorporate immediately a company in Brazil, or even if you incorporate a company in Brazil, you don't need to have any requirement to transfer such rights to your local entity in Brazil, which is different for the domain name. The domain name, I didn't include that, but the domain name, you can register in the first moment the domain name, the Brazilian, the .com.br, under the name of the company abroad, but after certain time, after 12 months, you need to transfer for your local entity in Brazil. Then I think the highlight here will be thinking that you have to protect your trademark, patent, industrial design in Brazil. The software and the copyright is different. You don't need to register in order to be protected. The registration is just will help you to facilitate the evidence to show who created that and when. But in accordance with the law, the software and copyright is the creation is already the date of the creation will be the ownership will not be showing by the registration. The registration is an option, it's not an obligation to be registered in order to have the protection, which is different from the trademark and patent and industrial design. And this is the main difference. I include the deadline also in the charter. You're going to see the trademark can be renewed every 10 years in design. Of course, you have to prove that you still have the purpose of the company comparable with what you have been requesting as a trademark protection, but this can be renewed every 10 years. The patent, you have a validity of maximum of 20 years for invention patents. After that, is going to be under the public domain. The industrial design, you have a maximum period of 25 years. The software, you're going to have a maximum period of 50 years, which is a lot for software. And the copyright, you have a maximum period of the life of the author and 7 years after his death. The copyright, I call the attention that you can assign the copyright, the economic right of the copyright, but the moral right, you can never assign that. What we call the moral right is for example, who creates the copyright, who is the author of the copyright. This is a type of right that you can never assign the rights on that. This is something that the law prohibits you to be assigned, but this will not interfere in any economic rights and what you can do at the end of the day with the copyright. Okay. In the next one, we included here something which is for practical terms is very important, and every company asks us about trade secret, whether or not this can be patentable or not. And trade secret in general, you protect it as a trade secret, you protect it under confidentiality. And we always can say that under confidentiality basis is not only important to have a strong confidentiality agreement with strong clause, but you have to act in the confidentiality basis. You have really to conduct your relationship with the parts involved, with who you are hiring, with the other companies that you are having the relationship with confidentiality, with the security measures, with the control of your confidentiality. And then this is the important part, because if the confidentiality is not protected, you're going to lose the rights that you're going to have. Here are some point of attentions in terms of limitation of scope of rights, violation of third party rights, obtention of the rights, and deadlines of considerations for protection. And we include in this part here what will be important in terms of each of the rights in terms of trademarks and patents, soft rights and copyright, and what you have to call attention. For example, limitation of scope of rights for trademarks, you are going to be limited for the Brazilian territories and what you protect in terms of good and service, because the trademark is always going to protect certain service or goods that you're going to protect under the registration. The violation before third party. If you own the trademark, the trademark is duly registered, you can be against a third party that's using your trademarks without your authorization, if the trademark is duly protected before the Brazilian Patent and Trademark Office. And then the idea of this charter here is to show you in the summary way some highlights that you can focus here of what you should pay attention in each of the rights here before third parties and deadlines that you can focus here. I will not go through all of this because of our time here, and that leave you some time for question, but this is a summary here of what we have in terms of points of attention here that we have to go through. Different of licensing and assignment. This is another point that always people ask for difference. A license is something that you authorize of use for a certain time. You're not assigning the rights. You're just asking, you're authorizing someone to use your trademark or your patent or your industrial design or the software or your copyright for certain period of time. In general, is under remuneration, and you can decide whether it's going to be exclusive or non-exclusive, or which terms and conditions you're going to define under your license terms and conditions. But the assignment of rights is completely different. You're really transferring the rights of the assignment to the other part. The IP contract, we highlight here some of the important elements of the contract in general that is discussed here in Brazil and I believe in other countries as well. But just to highlight here that this also is the important parts of provisions in the key elements of the contractual relationship, definition of scope of the licensing. This is a very important definition to be included in any type of license provision, confidentiality provision, as I mentioned before, ownership of the rights and IP enforcement, who is going to be the one that is going to enforce and what is going to be the ownership rights of who develop of what. In general, when you have a contractor relationship, we have to define if it's going to be a license or assignment, and if it's going to be a cooperation agreement or not, a simple license, and then depending on the structure and the complexity of what you're going to do in Brazil, because remember, we are here have a very large possibilities, not just a protection of your IP rights in Brazil, but you also can have business in Brazil in terms of licensing possibilities, in terms of co-development possibilities of also you have to think about if you're going to have employees in Brazil, how is it going to be the relationship of your team here in Brazil with your partners, with your third-party companies that you're going to have, if you're going to have research in Brazil, if you're going to have relationship with universities in Brazil, with research centers in Brazil, and this is going to be a large number of possibilities, and for each of them we have to think about how we are going to enforce the rights, how we are going to define each part of IP rights, and how we are going to include that in the agreement in terms of background IP, foreground IP, and all this should be defined in the agreement in order to avoid any discussion later on in the agreement. Oh, sorry, something wrong here. Sorry, and then products provision. Another important point here. In Brazil, we had recently a very important change, and very, very important change. I don't know if you already had business in Brazil before. We had before the Brazilian Patent and Trademark Office in the past, a very bureaucratic process with a lot of regulation, and also a lot of regulation under tax and and exchange rate provision in terms of remittance of payment abroad. This has been changed. And this change occurred very recently in Brazil, and the regulation was pretty old, and recent change has been very important in terms of less bureaucracy, possibilities of remittance with more flexibility, and the registration before the Brazilian Patent and Trademark Office is not mandatory anymore for remittance of royalties, which cause us much more flexibility and also less bureaucracy for the whole process. And then we have now transfer price rules applicable in Brazil. The registration of the agreement now is just for the registration of the agreement before the BPTO now is just for the validity before 30 parts. We still recommend for some kind of evidence of the agreement, including for tax reasons, but it's not an obligation anymore. And this whole change helps a lot significantly the scenario now in Brazil of negotiations of agreement, a new economic and stimulation of remittance of royalty, and also investments of technology and agreements between foreign companies and local companies for the technology transfer in Brazil. Of course, if you want to have more details on that, we have been working and going through the whole process of that, including with the BPTO. We work a lot on this whole subject here, representing the associations and being together with the BPTO in this whole process, and has been a tremendous benefit for the who works with this area here in Brazil. And as I mentioned, these attract investments, attract new agreements, and we start seeing the changes and the benefits of the new regulation in Brazil. Do and don'ts checklist for foreign companies operating in Brazil: protect and preserve the IP rights, use within contracts and licensing and assignment, and check if they are key elements preserving the IP rights, appointing local representative attorney-in-fact before the BPTO, because this is a requirement under the law, protect trade secret throughout NDAs, access control, internal policy. Do not rely on informal or verbal agreement. Pay attention, especially also for copyright agreements, because we also see a lot of agreements that you have sometimes not precise language and a very limitation on the agreement. And sometimes you want to have a more broader language on the agreement if you're from one side. Sometimes if you're in the other side, you do want to have a very limited language if you're maybe from the holder ownership side. And then depending which side you are, you want to have a broader or a limited language. But pay attention with the language on the copyright agreement, and also with the software. Going a little bit further, on the software license agreement, also we are already including several provisions and conditions, including also artificial intelligence approach on the software licensing agreement and development agreement, especially because if you're developing and having an assignment of software, of source code on software agreement, you do have to include AI provision. We cannot be a part of that anymore, of course. And then it's very important to include that on the software development agreement. All right. Do not skip clearance and search before using names, brand, and technology. I didn't mention that before, but it's very important if you're going to register a trademark or a patent in Brazil. you have to do a clearance to see the status, if the trademark and patent is clear or not for the use. Otherwise, you're going to invest in the trademark and patent in Brazil, and without knowing how and whether there is a prior trademark or patent protection in Brazil. And then it's important to do a prior search to see if you can use or not, if you have a good chance or not to use that trademark and patent in Brazil. In terms of patent, we conduct the search with, for example, patent technical engineers checking before the systems, not only the BPTO, but the international systems, whether the technology is clear, the patent protection is clear, but you also can use the FTO, the freedom to operate, to see if that specific technology can be used or not in Brazil. And this will give some comfort for the company, whether this could be a good way to go or not, or if you have to change a little bit the patch in order to protect that specific technology in the Brazilian territory as well. Consider not only what is protected in Brazil, but what is protected outside, because as you know, under the patent protection, we cannot have any type of prior disclose of the technology of the protection, the scope of the patent protection. And do not overlook the importance of the definition of IP ownership, employment or outsourcing agreement. The employment issue, it's also important because what is protected under the company relationship is owned by the company, but we cannot have, but anything that the employee will do outside of the employee relationship, it's owned by the employee. And then it's important to understand how it works and make clear how this is going to be done. We have several cases from different companies that sometimes this is not 100% clear, and we have been seeing situations that, well, half and half. Sometimes the employee will have some part of the ownership, others the company will have other part, and even situations that the employee will have the ownership, and then this whole relationship between employees and companies, we need to be carefully understood, and also how the companies are structured to compensate the employees, to have a good program to the employees in terms of the development of to incentivize, but at the same time to protect the company of the employee development and incentivize innovation internally to the company. I try to stop here to give some moment for any questions, and then to give the floor for my partner to also to have his time for the privacy aspect. Anyone would like to make any question now, or we leave to the end? It's okay as well.
Guys, anyone, any questions? Do you want to take advantage of having Tatiana here? Okay. If not, we can leave it to the end. But okay, Tachi, thank you so much. That was very good presentation on such a difficult topic and sometimes very dry. You did it really well. It was very, very good. Thank you so much.
Thank you.
You want to invite your colleague now?
I'm here.
Tomás. Oh, perfect.
Thank
Tomás.
you, Tati. It was really fantastic. Can you help me sharing the presentation? Thank you.
Sure, I'm here. Okay.
Perfect. I'd like first to thank you for the very kind invitation. It is always a pleasure to talk about Brazil's data protection law approved in 2018, which was a legal landmark here in Brazil, not only because of the importance of the topic, but also because of the democratic debate that we had here in Brazil that preceded the approval of the National Data Protection Law. My idea here today is to pass on fast flight through the slides. As Tatiana mentioned to you, we will share them later on with you. You will see that we have comprehensive information here about what we expect in terms of compliance from companies from data protection perspective. Please feel free to come up with any questions you might have. We began, if you can go to the next slide, Tati. We began discussing a draft data protection law here in Brazil in 2012. Brazil's Ministry of Justice opened 2 public consultations to gather inputs to prepare a draft, which was then submitted to Congress as a bill of law. Congress passed the National Data Protection Law, as I mentioned, in 2018, and it became enforceable, fully enforceable in 2020. Data protection is so important today here in Brazil that Congress approved a couple of years ago a constitutional amendment to change the constitution and include data protection among the fundamental rights, which, as you might know, are granted the greatest level of protection here in our constitutional system. We are still building up our data protection legislation through implementing regulations that are being enacted by the Domestic Data Protection Authority, we call ANPD, Autoridade Nacional de Proteção de Dados. In this context, we have been discussing here in Brazil what we could and should learn from experiences abroad, especially from Europe, in terms of best regulation. I'm happy to be here with you today, not only to talk about what we have learned, but also to comment on where we decided to take different approaches following new paths. And I would like to start by saying that the GDPR, the European GDPR, has inspired our legislation very heavily. Brazil's data protection law is closely modeled after the European GDPR and creates a legal framework for how personal data is allowed to be handled in Brazil. As I mentioned to you, our law was approved in 2018 because of the entry into effect of the GDPR and the need of having Brazil among the countries with a proper and adequate level of protection, so as to allow Brazil to be part of this huge world of the big data industry. Let's move to the next slide, Tati, because I would like to talk a little about the material scope of our legislation. The Brazil's data protection law governs the processing of personal data regardless of the means employed for such processing by an individual or by a legal entity. And the declared purpose of the Brazilian law is to protect the constitutional rights of freedom and privacy and the free development of individual personality. Processing has the very same understanding as in the GDPR, covering basically anything one does on personal data. Any data regarding an identified or unidentifiable individual, for example, numbers, IPs, etc., I mean, internet protocols, numbers, etc., should be considered personal data under the national law and therefore should be given the protection under the LGPD, the Brazil's data protection law. Like other countries, we have established a special category of data, I mean the sensitive personal data, and this category is given greater protection as it deals with an individual's intimacy. So everything related to racial or ethnic background, religious beliefs, political opinions, health, biometric data, among others, are considered to be sensitive data. Let's go to the next slide, just to show you that there is this intersection between the GDPR and the LGPD in terms of material scope. So the material scope is almost the same, and we can move forward, Tati. And in terms of subjects, of addressees, of the data protection law here in Brazil. The Brazilian law sets forth obligations applicable to data subjects. I mean, the individuals subject to the processing of their data, they are entitled to several rights. We have obligations applicable to data agents, such as the controllers, the ones that are in charge of the decisions regarding the processing of personal data, and also to the processors. I mean, those that process data on behalf of a data controller. And also we have some obligations related to data protection officers. The Data Protection Authority has already issued an implementing regulation on what we expect in terms of the DPOs. So these are the main addresses of our legislation. So in terms of principles, general principles, like the GDPR, our legislation lists the general principles that should guide the processing of personal data covered under its scope, while the principles laid down under the data protection law have the very same status among them. I would like to flag to you four which have been subject to greater scrutiny by Brazilian authorities, not only the data protection authorities, but also Brazilian courts. The first one is the principle of purpose. So the processing of data needs to have legitimate, specific, and explicit purposes, duly informed to the data subjects, with no possibility of subsequent processing in a method that is incompatible with such purposes. Also, the principle of necessity. The processing should always be limited to the minimum necessary extent in order to achieve its purposes. So it should encompass all relevant, proportional, and no excessive data for processing purposes. Also, the principle of transparency is very important here in Brazil. Under this principle, there is a guarantee to the data subjects of clear, precise, and easily accessible information on the processing of data and respective processing agents, with due regard for trade and industrial secrecies, and also the principle of accountability. This principle is very important when it comes to compliance with data protection law. It is expected that all processing agents demonstrate the adoption at all times of suitable and efficient measures in order to prove their compliance with personal data protection rules and the effectiveness of such measures. In terms of accountability, the first measure we expect that data processing agents adopt here in Brazil is to keep the records of what they do in terms of data processing subject to the Brazilian law. Let's move to the other one. Under the Brazilian law, a personal data processing to be valid needs to rely upon lawful basis. The national law lists down 10 legal bases for non-sensitive data and 8 for sensitive data that could validate a certain processing, being consent one of them. Besides consent, we could rely, or a company could rely, for example, on the existence of legitimate interests for the processing of data. Legitimate interest of the controller or a third party is a lawful basis for the processing of non-sensitive personal data here in Brazil, like in Europe. We can also rely in the execution of a contract as a lawful basis for the processing of data. But what is important for you to know is that there is no hierarchy here in Brazil between the lawful basis, and therefore consent should not be taken as the necessary. Consent should not be taken necessarily as the safe harbor here. Let's move one to the other one, Tach, to talk about consent, because regarding consent more particularly, to be valid under Brazilian law, we have specific requirements we expect data subjects to give controllers a free, informed, and unambiguous, unequivocal manifestation agreeing with the process. Controllers are expected to inform data subjects of the specific purpose of the processing before having or obtaining data subjects' consent. Brazilian law does not authorize generic authorizations. They are not accepted, and they are considered null and void. So we expect consent to be specific vis-a-vis the purpose of the processing. And what is important for you to know is that consent here in Brazil can be revoked at any time by request of the data subject. This is one of the rights data subjects are entitled to. In terms of data subjects' rights, it's the next slide. The Brazilian law creates 10 rights for data subjects. They are found in Article 18 of the national law, and they empower individuals with the rights shown in that slide. I mean, the right to confirm the existence of the processing, to have access to their data, to request correction of any incomplete, inaccurate, or out-of-date data, the right to request anonymization, blocking, or even deletion of any unnecessary or excessive data. There is being processed in non-compliance with the data protection law, the right to request portability of the data to another service or provider, deletion of data that's not being processed with the data subject's consent, if consent is the lawful basis applicable to such processing, information about what's being done with the data, the entities with which the controller has shared or exchanged data with, the possibility of denying consent and the consequence of such denial is more in term. This right covers more requirements regarding transparency. Also, as I mentioned to you, the right to revoke the consent at any time without any charge. The rights to file petitions against the controller or any data processor before the data protection authority, and also the right to request a review of decisions that are made solely based on automated processing of personal data. In terms of territorial scope, what I can say is that we have a very transversal and multi-sectoral application of the law, meaning that it applies to both public and private sector, as well as online and offline. Our legislation has an extraterritorial application, which means that websites, companies, or organizations that process personal data from individuals in Brazil are bound to comply with the domestic data protection law, regardless of where in the world they are owned or operated from. Actually, in Article 3 of our law, it is defined that data protection rules apply to data processing within the territory of Brazil, within the Brazilian territory, data processing of individuals who are within the territory of Brazil, regardless of where in the world the data processor is located, and also to data processing of data collected in Brazil. The Brazilian law does not only protect Brazilians, but all individuals whose data is collected or processed while in the national territory. So it's the very same approach of the GDPR. We also have, if you can click and enter, Tati, just to show the second part of the slide. We also have several provisions regarding international transfer of personal data. To do so, specific guarantees need to be in place. We expect that international data transfers are carried out only to countries with an adequate level of protection as recognized by the Data Protection Authority. To date, we have no country with such a recognition, but we expect this to occur very soon. Otherwise, the expectation is that the controller offers and proves a guarantee of compliance with the LGPD in the form of SCCs, the standard contractual clauses. It's important for you to know that the Data Protection Authority recently approved the Brazilian SCCs. They are not fully compatible with the European SCC. They are quite different. The best approach here in Brazil right now is to rely on SCCs, since we don't have decisions from the Data Protection Authority recognizing other jurisdictions as having the same level of protection, but we expect this to occur very soon. Let's go to the other one. In terms of sanctions, the Brazilian law is clear when it comes to the consequences of non-compliance with the law, and the penalty system ranges from warnings that can be issued in case of violation and non-compliance with the intent of having the entity adopting corrective measures, to daily fines, to fines up to 2% of the annual turnover here in Brazil, with a maximum of 10 million US dollars per violation. What else? It is the responsibility of the Data Protection Authority here in Brazil to enforce such sanctions in the country. And talking about the Data Protection Authority, if you can go to the other one, Tachi. The Data Protection Authority is the one responsible for the enforcement of the data protection law here in Brazil. It was created by the data protection law and established by a presidential decree in 2020. It had its board of directors appointed also in 2020. We have a board of directors made of five directors. And the authority is to date fully into force. We had a discussion in the past whether or not this authority should be granted an independent status, and we changed the law to give this independent status to the Data Protection Authority, so as Brazil could be recognized by other countries, by its peers, as having the same level of data protection. The authority key objectives are to enact implementing regulations. We are working hard on that, and also to establish the technical standards, supervise and audit the compliance with the data protection obligations. Also to educate about the law and its correct obligations, deal with notifications of data breaches, and enforce its sanctions. We have been seeing the Data Protection Authority working very hard in implementing regulations, but also they are adopting what we call a responsive regulation approach. They are issuing guidelines, soft laws, white books, etc., with recommendations for company. They are preferring to educate and to give time for companies to adjust their business to the new standards that are required in terms of data protection, then enforcing the law with the application of penalties. I think that's it. This is a flow in terms of enforcement of the data protection obligations here in Brazil. So basically, the Data Protection Authority has authority over both controllers and processor data subjects. They have the right to file petitions with ANPD, with the data protection authorities. And so this is a systematic way of seeing how the data protection law is enforced here in Brazil. I also have here a couple of slides about this is just to talk about an emblematic case. We can pass that this slide and just give you a very short message in terms of compliance. Since you guys are considering entering the Brazilian markets, I mentioned to you, accountability is the general rule when it comes to data protection. There is the general expectation that processing agents they know what they do with personal data here in Brazil, so they are expected to keep the records of what they do in terms of processing transactions, especially, and also to know the legal basis and identify the legal basis that they rely upon for such processing, especially when based on legitimate interests. And what the data protection law imposes on companies doing business in Brazil is to accept that the processing of personal data may expose individuals to risks, and to mitigate these risks by adopting a series of internal measures, for example, privacy policies, information security policies, adapting existing contracts to include provisions that are mandatory under the data protection law, adopt SCCs as the case may be in case of international data transfer. And I know that you are totally aware of that, but data protection, as here in Brazil or anywhere in the world, is no longer just an exercise of a tick box. I think that's it. We'll have here more a couple of other slides about compliance. Feel free to pose any questions you might have, or to share your comments. And that's it. Thank you.
Thank you so much, Tomás. The same as Tachi, you managed to do a great explanation in a topic that is very difficult, very, very dense. So congratulations. That was a great presentation. Thank you so much. Guys,
I have the first question.
Yeah, oh, go ahead then, Julia, go ahead.
Tomás, just to understand the role of the DPO, the Data Protection Officer. So as a foreign company expanding to Brazil, can I designate an external service provider, like a law office firm or a consultancy, to act as my DPO under the Brazilian LGPD? Or no?
Yes, we have, Julia, an implementing regulation on DPO setting forth the specific requirements, and also providing for on some waivers. So if a DPO is mandatory, yes, you can have a DPO as a service. You can hire a firm. We have several firms here in Brazil offering these services. But I think Tachi agrees with me that I think it is a first step when you are entering the Brazilian market, but it is always considered a good practice to have your own DPO when you become bigger here in Brazil. This is the expectation that companies show their concerns in terms of data protection. Having a DPO in-house is seen by the Brazilian Data Protection Authority as a good practice. What we expect in terms of DPO, the DPO is the one that is in charge of being the liaison between data subject and also the Data Protection Authority. There is no need to have a Brazilian as a DPO, but it should be someone that has some knowledge of the Brazilian Portuguese, because he or she will be the one with all these engagements.
Yes, and just as Tomás mentioned, just for you to know, the law does not require the DPO to be an individual or a company or someone outside or inside the company. The law, it's open in that sense, the regulation. And as Tomás just mentioned, it's very common That at the end of the day, it's someone internally by the company, but assisted by a group of people that from technical expertise, from a legal expertise, and then this is common. The DPO internally will have what we call the privacy committee in charge also to assist the DPO with background. The DPO will have the rules to have this link and to be in charge of this communication between the data subjects and the privacy authority, the company, but also at the end of the day, the entities, the companies will have, if it's possible, the privacy committee also, and also the DPO, the assistance of a backup in terms of support.
Got it. Thanks. I have a second question.
Yeah, just let's see, guys. Does anyone else has any questions? We know that this is a very tricky subject, but I highly encourage you to take advantage of Dimarest's team here. So if you guys have any questions at all about this subject, I suggest you ask. Don't be shy. I know you guys are shy. I know the guys in Japan are probably very tired already as it's very late, but I highly encourage you guys to ask questions. Okay, Julia, if you want to go.
Okay. I have a question regarding the timeline, Tachi. How long does it take to register a patent or a trademark if I'm a
question.
foreign company coming to Brazil?
Good question. For trademark, it's around 1 year without opposition. In the past was 8 months, but now it's will be almost 1 year without opposition, without any obstacle during the process. But for a patent, it's 8 years. It's still a long process, the backlog in Brazil. Yes, but as soon as you have at least filed the patent, you have the priority on your patent protection.
Okay. Does anyone has any other questions? Well, I guess that's it then, guys. Tatiana and Tomas, thank you so much for your presentation. That was really great. We really appreciate you guys for being here for us. Okay, thank you so much. And guys from ScaleUp in Brazil, me and Julia, we're gonna stay behind to ask any question, to answer any questions you have about the program. We are now approaching very closely to the immersion period. So if anyone has any questions, I would particularly like to talk with Offer. Offer, if you're still here, I would like to stay behind so we can talk a little bit. And anyone else, if you have any questions about the program, please stay behind. Thank you so much. Thank you.
Bye-bye.
Thank you.
Bye-bye.
Bye-bye.
Thank you.
Bye, guys. Thank you.